Okay, here we go. Hello, hello. 10:48. 10:54.
Okay.
Our next speaker is Crystal Witterick from Davies Ward & Beck, who will speak on trans-border investigations, how to advise your client.
Good morning. Is this on? Can you hear this?
Hello, hello. We on? I think so.
Okay. First, let me tell you why you need to care about this topic. Some of you may think you practice law in Canada, but in fact you practice law, at least in the competition area, in a trans-border environment. There have been a number of recent cooperative efforts between the U.S. and the Canadian antitrust authorities to convict companies of criminal conspiracy matters that have occurred in a trans-border context. I've given you, or I've left outside, a paper which outlines some of these recent developments, and you can pick that up outside, I understand. In particular, there's been a recent conviction against Canada Pipe, which was a Canadian company who entered into an arrangement with a U.S. company whereby they agreed that one would operate in the U.S. market and one would operate in the Canadian market. The Canadian company was fined $2.5 million as a result of enforcement coordination between the U.S. antitrust agency and the Canadian antitrust agency. And the reason why you need to care about that is because if you're advising the Canadian company, information in possession of the Canadian company, information that you may hand over to the Competition Bureau, may find its way across the border and result in prosecution of related entities, civil actions from the U.S. against your client. So you have to understand that there are some rules about sharing of information cross-border. The first rule is that there are protections in the Competition Act in Section 29 which say that the director can only share information with other agencies for purposes of enforcement of the Act. There's a debate going on right now about what that means. The director has issued a number of information bulletins which you can obtain from the Bureau on this issue, but as a result of the Schreiber case, which is the case involving Schreiber and Mulrooney, where the government applied to the Swiss authorities for information. As a result of that case and a decision of the federal court, which ultimately said that in order to get information from a foreign authority, you had to comply with the Canadian requirements for obtaining that information. The director has postponed his efforts to clarify his obligations about the exchange of confidential information. So that's a current issue. So if you are advising a client about providing information to the Canadian Bureau, either to settle a matter in response to an information request in the context of a merger, because mergers are criminal in the U.S., you need to take a look at the rules regarding the director's ability to provide that information. Conversely, you may have a client who gets a request from the U.S. for information. The FTC or the Department of Justice may send to your client, because they're an affiliate, a sub of a U.S. company, an information request saying, we want you to provide to us certain information because we're investigating company X in the U.S. If you provide that information, you should appreciate that there are some risks because, again, that information can be shared back across the border to the Canadian authorities. It could implement your client in Canada if there's some question about their activities. And what you need to take a look at there is blocking legislation. There are statutes in Ontario, and there's a federal statute that prohibits the provision of records across the border. It's not a statute that's used very often in Canada, but it's there. It actually arose out of an antitrust investigation in the uranium industry, and the federal government got quite upset because the Americans were attempting to just come over here and seize records as of right, and they implemented this legislation to stop that. So you need to keep that, that legislation in mind if you're faced with a request for information from a foreign jurisdiction. Other things that you need to be careful about is if you're entering into some kind of settlement arrangement with the Bureau, you may, for example, resolve a matter with a prohibition order or an undertaking, in which case there will probably be an agreed statement of facts. You need to be very careful about the agreed statement of facts because that information, again, can be shared. It may also be on the public record, and it could be used by a U.S. company to sue your client in Canada. Canada generally uses search warrants to get at information that may be relevant to a competition investigation. Again, if you get if a search warrant is issued against your client, you first of all want to get access to the information to make sure that the warrant is valid and ensure that they're only searching within the scope of the information. And second, you want to ensure that if you're talking to the director about the warrant, and usually you will in order to try and narrow the scope of the search, you want to ensure that any privileged and confidential information that is provided or sealed, usually it's sealed and given to the director under seal until the issues are resolved by a court, is not going to be provided across the border, because if that happens, it may not be subject to the same privilege and confidential rules in the other jurisdiction. The other issue that you need to be careful of in searches is the director has developed very sophisticated software to get at computer records, and the Competition Act gives him the right to search your client's computers. There are problems if your client's computer network is linked to a U.S. parent, U.S. affiliate, because, as you know, you can access documents in the United States through a computer located in Canada, and certainly the director will try and do this. There are some issues about whether the jurisdiction of the warrant extends to those records in the U.S. Also, there are issues about identifying where a record is located that you will want to consider. There is no settled case law in this area. In fact, it's just a recent issue which is being looked at internationally to determine the obligations of countries in this area. There's also a question about whether the parent company has an obligation to facilitate access to those computer records, because, of course, he could just pull the plug on the computer system and the director would be out of luck. So that's another issue you need to keep in mind. The final thing is that there is extradition legislation. There's actually a treaty between Canada and the U.S. which allows either side to request extradition of somebody who's involved in antitrust activity. And Canada has recently tried to do this by requesting extradition of somebody in the U.S. who's actually alleged to have engaged in misleading advertising, which doesn't seem all that serious to warrant extradition, but there you go. He was ultimately convicted because he came here voluntarily and fined. So he now has a criminal record which precludes him from coming across the border again.
Great. Thank you, Crystal. Our next speaker is John Owen from Thorstensons. I will speak on choosing a tax haven.
Okay, I'm going to focus today basically on the use of tax havens by persons resident in Canada to carry on business outside Canada. I'm sure some people might be interested in, for example, a tax haven that you would choose to leave Canada and move to, but that really doesn't involve much in the way of Canadian tax issues, because once you've left Canada, of course, there are no Canadian tax issues. The kind of structure I'm thinking about and focusing on is a Canadian corporation that owns or wants to set up a foreign corporation to carry on a business in a tax haven, or to carry on a business outside of Canada and is thinking of using a tax haven. What kinds of issues do you have to consider from a tax perspective? Well, first of all, let's consider what a tax haven is. And generally speaking, I guess it's obvious. It's a jurisdiction that imposes little or no tax. However, on its face, it's obvious. In fact, some of the jurisdictions that we consider to be tax havens, Barbados as one example, and to a lesser extent Ireland is an example, in fact have special regimes that apply either to a subset of corporation or to a subset of taxpayer. So the place itself is not in strictest sense a tax haven, because it does impose regular taxes on its citizens and or its residents or its domiciles, but in certain limited circumstances it does give a very low rate of tax. In Barbados, this is accomplished through a so-called international business company, for example. It has a tax rate of a maximum of 2.5%. If you want to use a tax haven jurisdiction to carry on a business, then in order to get the benefits of the Canadian tax system, as I say, you have to have a Canadian parent corporation on top. And the jurisdiction in which the corporation, the subsidiary foreign corporation, is located must be a so-called designated treaty country. And this means a country with which Canada has a bilateral income tax treaty that's currently in force. And this is an important point, because Canada's tax system is an exemption system, and the way it works basically is if you are a foreign corporation that has a Canadian parent resident in a designated treaty country, and that corporation carries on business in a designated treaty country, then the income from those operations go into a special account called exempt surplus that can then be paid to Canada as dividends free of tax. The reason it's important to have a Canadian parent corporation as opposed to a individual owning the shares of the foreign corporation is that exempt surplus account only applies to Canadian corporate shareholders. It does not apply to individuals. An individual that receives a dividend from a foreign corporation is taxed on the entire amount of the dividend as ordinary income, and there are no gross-up tax dividend benefits associated with dividends from foreign corporations. What are some of the considerations that go into choosing a tax haven? Well, I'm sure other people have touched on these. The non-tax issues would include the location of the tax haven. Of course, it has to be practically located, so you have to have access by air at the very least, and perhaps by water. It has to have an appropriate infrastructure to be able to support the kinds of business activities that you're proposing to carry on in the location. It should not have exchange control, since this obviously would inhibit the repatriation of funds from the business activities. Language can be an issue, and quite often the tax haven jurisdictions with which we have treaties, English is widely spoken, and that's sometimes important. I guess French might also be an alternative. It hopefully would have a legal system that is comprehensible to Canadian counsel, because that makes it a lot easier to assess the kinds of liabilities and other problems that you might get into down there. From a tax perspective, it may be important that it have a comprehensive treaty network, because you may be relying on this particular treaty or tax haven location to carry on business in other locations, and you would like to be able to obtain the benefit of any treaties that tax haven jurisdiction has with these other locations. For example, reduced rates of withholding tax, protection from being found to carry on business in another jurisdiction, those kinds of things that you find under typical treaties. And of course, you also want political and economic stability. What are some of the most important tax issues to consider when using a foreign jurisdiction that is a tax haven? Well, the most important perhaps is where your foreign corporation is in fact resident. As I mentioned, the corporation has to be resident in a designated treaty country, and that means, for the purposes of the Income Tax Act, that it should be resident both under the common law principles applicable in Canada and also under the terms of the treaty that we have with that country. And for the purposes of determining whether it is resident under the treaty, there are special rules that say even if under normal circumstances the treaty wouldn't apply to this particular class of corporation, for example, the Barbados Treaty specifically states that it does not apply to an international business company. We assume it does apply for the purposes of determining whether it's resident under the treaty. It's very important, of course, that the company not be resident in Canada, and since there is a common law test, of course, you look to central management and control, where the board of directors meet, where the meetings, where the decisions that actually govern that corporation are taken at those meetings, those kinds of factors. It is very important to keep central management and control outside of Canada and in the tax haven in which you're purporting to be resident. The other big issue from a tax perspective is where is that company carrying on its business. Again, it's important that it carry on the business in a designated treaty country in order to get the benefit of the exempt surplus treatment. It's also equally important that it not be seen to be carrying on business in Canada, which again is a determination under common law and also under the broad statutory definition in the Act. If it is carrying on business in Canada, then of course it would be subject to tax in Canada on any income from that business. So in that regard, you want to certainly be sure that the corporation is not carrying on business in Canada, but you also want to ensure it is carrying on in a jurisdiction that is a designated treaty country. The country where it's resident and the country where it's carrying on business, of course, don't have to be the same as long as they are both designated treaty countries. And perhaps finally, you have to ensure that if you are, for example, selling goods into this company or other such things, you have to be aware of transfer pricing issues, and you should try and develop a transfer pricing policy right off the bat that isn't going to take you offside. Revenue Canada sets out its views on transfer pricing in Information Circular 87-2, and it's always instructive to look at that information circular when you're considering setting up one of these companies.
Great. Thank you, John. Sticking to tax for a few more minutes, our next speaker is John Rodwin of Kavanaugh & Cook, who is going to talk about U.S. thin cap rules and withholding tax.
Thank you, Jim. I think it's only fair to warn you that in my first court appearance, the judge had to stop me in the middle of my opening remarks to tell me I was speaking so fast that not only could the judge not follow me, the jury couldn't follow me, and nobody in the courtroom could follow me. Given the 3 cups of coffee I've had this morning and my 6-minute deadline, Jim, if I go too fast, please stop me and tell me that nobody's following. I would like to leave you with 6 short questions and short answers to encapsulate the thin capitalization area. There's more detailed and organized information in the materials that you may want to look at, but I think if we focus on these 6 issues, it should give you a basic understanding of it. The first issue is, when do we care about thin capitalization of a U.S. corporation? Really, any time when setting capital, the issue of thin capitalization comes up in connection with a closely held corporation. So it can be a U.S. Subsidiary of a Canadian parent, or it could be a U.S. corporation with U.S. shareholders. This is not necessarily particularly a cross-border issue. It's an issue that totally U.S.-owned and operated corporations deal with as well. There's a side issue under the so-called earnings stripping rules that has a special limitation on interest deductions. I don't want to get into that here because it's fairly technical, but it's outlined in my materials. What is thin capitalization? It is what it says. A corporation is thinly capitalized if the capital of the corporation is thin in relation to its debt, or it's said a more simply way, there's very little equity and there's lots of debt. Frequently it's referred to as not as thin capitalization, but the debt-equity ratio. And if you have a high debt-equity ratio, the corporation's thinly capitalized. For example, if a shareholder forms a new U.S. corporation, contributes $1,000 of capital to the company, and loans $100,000 to the corporation for it to be able to operate, there's a debt-equity ratio of 100 to 1, and the corporation's thinly capitalized. Okay. Question 3, what is the real issue we're dealing with here? The real issue is not thin capitalization. It's a shorthand term which tax lawyers and other practitioners use to refer to a different issue. And the real issue is whether or not an instrument which purports to be debt is really debt for U.S. tax purposes, or whether it's really a loan. There are a lot of whether a corporation is thinly capitalized is just one of many factors that a court would look at to determine if a debt instrument is in fact debt. So we should think of this really as the debt versus equity issue, not as the thin capitalization issue. Okay. Question number 4. Why do U.S. tax practitioners care about thin capitalization, or more correctly, debt versus equity? Debt in the United States is preferred for tax planning purposes when funding a corporation for its operations, primarily for 2 reasons. 1, interest paid on a debt obligation is deductible to the paying corporation. That reduces income of the paying corporation, it reduces taxes. In the alternative, if the corporation was paying a dividend on stock, that dividend is not deductible, and therefore the repatriation of profits to the shareholder, whether it's in the U.S. or Canada, comes at a higher cost because it's after-tax dollars. The dividend has to be paid after taking into account the tax the corporation is going to pay. It's one reason why people prefer debt. The second reason is that the repayment of debt is a return of capital to the lender, and therefore a non-taxable transaction. If instead a shareholder has a partial redemption of stock, ordinarily, in most cases, that partial redemption of stock is treated as a dividend and it's taxable. In the United States, redemptions of stock are treated first as a return of profits and taxable, and only secondarily as a return of capital. And for that reason, again, there's a preference to fund with debt versus equity. How does the issue arise? Corporation is formed. It is, quote, capitalized primarily with debt and not with equity. Time goes by. The corporation pays an interest deduction on the so-called debt. More time goes by, a portion of the so-called loan is actually repaid to the shareholder. More time goes by, the IRS audits the transactions and says, you, corporation, what you called an interest deduction, that's not really a deduction, it's a payment of dividend. I'm going to deny the interest deduction for that, and you, the corporation, are going to have an assessment for taxes due. Likewise, you, shareholder, you thought you were getting a on the return of capital, you thought, on the repayment of the loan, you thought you were getting a return of capital. You weren't. That's really equity you're holding. It's not debt. Therefore, you received a dividend, and you're going to have to pay tax on the receipt of the dividend. Okay. So that's how the issue arises. The final question, what do we as lawyers do about this? How do we deal with it? Unfortunately, there is no bright line test. There's no safe harbor so that you can tell a client, if you meet the following 6 criteria, your corporation will not have a debt versus equity problem. There's a variety of cases that dealt with this issue over a number of years, and they came up with maybe 25 different circumstances that a court may look at, and then like any area where each case is decided on its own facts and circumstances, it leaves us as lawyers frustrated because each court has its own particular bent as to how it analyzes the facts and circumstances. You can look at the cases and see sort of a trend to what the courts look at, but you have to do what we as lawyers do. Your client comes to you, you're going to have to apply your own judgment to a particular situation, looking at your particular client, that client's particular factual situation, and then looking at what the case law holds. The best listing of short list is included on my outline under what's called Section 385. It was a statute that Congress passed in an attempt to deal with this issue in a very general way by instructing the Treasury Department to adopt regulations, and Congress listed 5 different factors which, among other things, ought to be considered. And it's a good test of factors. Whether there's a specific instrument that evidences the debt which provides for a regular payment of principal and payment of interest. 2, whether or not the debt is subordinated to or has preference over other debt. Obviously, if the shareholder debt is subordinated to debt of all other creditors, it looks more like equity than true debt. 3, the ratio of debt to equity of the corporation, thin capitalization. So it is one of the factors we have to consider. Whether or not the debt is convertible into stock. Again, if it's convertible, it's going to look more like equity than it is like true debt. And finally, the relationship between holdings of stock in the corporation and debt. If the debt of a corporation is held pro rata by all of the shareholders, it looks more like stock than if one shareholder had advanced money to the corporation and other shareholders did not. I'd like to end this with one example, which I think illustrates it. Assume you have 5 shareholders that form a new corporation, and each shareholder contributes $1,000 to the capital of the corporation. The corporation needs $50,000 to operate, and it's going to come from the shareholders. In the first example, each shareholder loans $10,000 to the corporation, so the loan is pro rata, it's convertible into stock. In this example, it's subordinated to debt of other debt of the corporation, and the payment terms are deferred or uncertain. You've got a 10-to-1 ratio now of debt to equity in a situation where you have to tell your client you think it's fairly likely that that debt may in fact be equity. In another situation, it's all loaned by one shareholder. I'm done? It's all owned by one shareholder, and it's secured. Therefore, it looks more like true debt, not equity.
Thank you, John.
I should have spoken quicker.
thought I was going to have to run over there and grab you.
Sorry about that. I must have missed the first tap, warning me of a minute.
Our next speaker is Keith Tuomi from the Bank of Nova Scotia, who will talk about the very topical subject of international bank secrecy laws.
Thank you very much, James. I must caveat my remarks this morning by saying that the remarks that I make are not necessarily those of the bank. They're mine personally. They may mirror those of the bank, but I have to say that. So, bank secrecy is an extremely important area, and already this morning we've heard a number of speakers whose topics have touched on issues of bank secrecy. Both Charlotte Janssen and John Owen discussed issues of tax havens and their implications. I think it's important to note that as a bank, we view, or the Bank of Nova Scotia and all Canadian banks view bank secrecy very highly. As a matter of fact, if you go into Scotia Plaza, which is the main branch at some point, the bank even has a very small booklet called Scotia Bank and You, A Question of Privacy. Now, bankers will tell you over and over again that bank secrecy is the cornerstone of banking, and it is. One of the reasons I picked this topic is that in some ways it's a bit ironic that the Canadian law on the subject is quite simple to discuss, but it's also at first blush, but it's not actually all that simple. Canadian bank secrecy law is based on the Tournier case. The Tournier case is the English case from 1924, which in Canadian cases, almost by rote, 4 exceptions are almost always cited as being the exceptions in which a bank may disclose information about its customers to third parties. In the Anglo-common law jurisdictions, Canadian British banks owe an absolute duty of confidentiality to their clients. These exceptions are often sort of almost parroted out. While all of them have their place, some of them are more important than others. And I should say, in an international context, remember, because there are many different legal systems in the world, In Canada, we do rely on, as part of the Anglo common law world, we do rely on the Tournier case. And in other Anglo common law jurisdictions, in the Commonwealth, as a matter of fact, such as Malaysia and Singapore, there are statutory variations to the Tournier principle. So our bank, for example, operates in 46 countries. Many of these countries are Anglo common law jurisdictions, Cayman, Barbados. The bank's opened up in Labuan, by the way, and Labuan is an offshore financial center, which two of the previous speakers have referred to. But in Canada, we still pay credence to Tournier and what the exceptions are. Now, bankers like to rely on two of these exceptions more than the others. They like to rely on compulsion of law, and they like to rely on the express consent of the customer for disclosure. In most of the standard form banking documents that our bank has, be it agreement reoperation of account, a reimbursement agreement for a letter of credit, there will often be a provision in there by which the bank takes onto itself or ensures that the customer will allow expressly in writing for disclosure of information in certain circumstances. And the bank likes to rely on this because this is one of the four exceptions in Tournier. It's the one that is probably the strongest. The other really strong one is compulsion of law. Both of these, however, are not foolproof. In the Tournier case and in other Canadian cases, there have been instances in which the bank tried to rely upon implicit consent. That's why there have been problems with that, and there's some Canadian cases that go into it. But I just want to say that basically the bank will rely on a court order in the jurisdiction in which the account point is located. If a bank is served with a court order in the account point, the jurisdiction in which the account point is located, 9 times out of 10, after some sort of back and forth, the bank is going to have to disclose information. A number of the previous speakers again referred to international tax havens. A recent example which occurred, which is not referred to in my paper, the T5 slip issuance matter. The T5 slip issuance matter referred to the fact that Canadian residents who are taxable on their worldwide incomes often have accounts in offshore branches because the Bank of Nova Scotia operates in 46 countries. The Bank of Nova Scotia often, through its offshore affiliates or subsidiaries, holds accounts for these Canadian citizens, and Revenue Canada was putting pressure on Canadian banks, including the Bank of Nova Scotia, to disclose information relating to these accounts to Revenue Canada as part of, budgetary constraints and everything else in terms of the Canadian government needing more money these days. And the Bank of Nova Scotia found itself in a very difficult position as I referred to in my paper, the extremely famous Bank of Nova Scotia case in 1984 in the Cayman Islands and the Bahamas. Again, there's always this tension between what local bank secrecy laws say and what companies, not only banks but other companies, in terms of having a multi-jurisdictional operation, have to be able to do in terms of complying with local law at the same time as being good corporate citizens. Oftentimes, other examples which will arise, which I referred to parenthetically in my paper, include things like Revenue Canada wants to do an audit. Revenue Canada is interested in getting banking records from offshore branches. Offshore branches say to themselves, well, look, if we send this information back to head office, we might be breaching the bank secrecy laws of X, Y, Z. Oftentimes, statutes in foreign countries allow for exemptions to do this. They will allow for certain sorts of things. The problem is there are certain types of investigatory measures, such as a Revenue Canada audit, that bank secrecy laws in foreign countries may not allow the bank to do, and the bank will be in a catch-22 situation like the famous Cayman subpoena story. I just want to mention 3 cases very quickly. There are 3 cases in which the other 2 duties, which I haven't disclosed very much, the bank's own interest, and the 4th one, I think, which is the duty to where there's a public duty to do so. These are much more circumscribed. I have 1 minute. These are much more circumscribed areas. The bank's own interest is a very limited one. That's basically, if you read the Tournier case, is a very small exemption. But the other one, Canadian courts, especially the British Columbia Court of Appeal in a case of CIBC versus Sayani, 1993 decision, tried to open up the duty to the public to disclose. And they said that at that time, and I will quote, and of course they based this decision based on the other 2 decisions in the Tournier case, not Mr. Justice Banks' decision, but Lord Justice Scrutton and Aiken. They said, well, both Scrutton, Lord Judge, and Aiken, Lord Judge, specifically include protection against fraud among the purposes for which a bank may disclose a customer's confidential information to a third party, it seems that this exception, that is to say prevention of fraud as opposed to its prosecution, probably also falls within the second category enunciated by banks, that is to say where there's a duty of the public to disclose. So there's evidence of the Canadian courts trying to say that if the bank has knowledge which might prevent a fraud, maybe they can disclose. There's another case, the Royal Bank versus Arts Welding and Machine Shop, an Alberta Queen's Bench case, which says that there may also be a new category. Again, they look at the Tournier case. Again, they try to read into it, and they say there may be a new category of disclosure, and that is where the interests of justice require disclosure. Again, I don't think our bank is going to rely on those. I haven't seen those put in terms of a Supreme Court of Canada's decision yet. But there is this emphasis of if there's not a statute that the bank can look at, like compulsion of law, perhaps, and if the federal parliament hasn't taken authority to do that, maybe there is the ability now for courts to try to look a little bit more closely into disclosure and try to impute what parliament would otherwise do.
Great, thanks, Keith.
Okay.
Save me having to
Okay.
physically restrain you.
Okay. I want to do that.
Our next speaker is Elo Tulving-Blais, who is a sole practitioner and will talk on life after Lowen, lessons learned on doing business in the U.S.
Thank you. Lowen Group Inc. is a Canadian funeral home company. 6 years ago, it started to expand into the United States. In its first year, it ran into a roadblock. A Mississippi company accused it of having breached the contract. The other side sued for $7 million. No, actually, they sued for $26 million, and they offered to settle for $7 million. No, I got that mixed up. Lowen was confident it could win in court. It was stunned when the jury awarded the other side $500 million. In many states, if a jury awards an award that seems ridiculous, the losing side can take the case to a single judge and ask to have it reduced. This is what Lowen did. It was stunned again when the judge decided that the award was totally appropriate. To appeal, Lowen would have had to post a bond worth 125% of the jury award. In other words, $625 million. It was given 7 days to do so. Lowen considered declaring bankruptcy, but at the last minute, the party settled for $175 million US. What are the lessons we can learn from the Lowen disaster? There's 5. Lesson number 1, we need to recognize that the US is a foreign country. We need to exercise the same level of caution in the US as we do in the emerging markets of the world. Too often our Canadian clients think that doing business in the US is very much the same as doing business in Canada. They're wrong. Compared to Canadians, Americans are aggressive in their business culture. In the States, people and companies seem constantly on the lookout for someone to sue so that they can retire or add to the company's bottom line. Lawsuits are used as business tools. Now, this is easy in a country where contingency fees make lawsuits affordable for the plaintiff and costly for the defendant. The laws in the States can also be very different from ours. In Canada, we can expect a measure of certainty and fairness from our legal system. It's so much so that we often hear defendants and their lawyers say of a lawsuit, let them sue. It's one thing to sue, it's quite another to win. Now watch out, that's a Canadian saying. It doesn't apply in the US. There, anything goes and anything can happen. Lesson number 2, proactive measures must be taken before going into the US. One of the best proactive measures is a formal contract drafted from an international perspective. This should be done always, in large cases and small. A few months ago, you may have seen a story in the newspapers where a man in the US took his car in for a paint job. The new paint job came back with a few scratches. The man sued, and the jury awarded $4 million in damages against the car painting company. Now, if a transaction worth a couple of $100s can turn into a $4 million jury award, think what can happen to your client when it goes into the U.S. with a modest business deal. A written contract will allow you to cover off the very risks that almost put Lowen 6 feet under. Lesson number 3, an arbitration clause is a must. International contracts, as you know, usually include an arbitration clause. If a dispute arises, the dispute is going to be decided by an arbitrator, not a court. Nowhere is this clause more important than in the U.S., where juries must be avoided at all costs. In Canada, jury trials for commercial disputes are uncommon. In the United States, they're the rule. A plaintiff will often choose a jury trial precisely because of a jury's tendency to award high amounts. Lowen now says that the need for an arbitration clause in contracts is the single most important lesson that it learned from its Mississippi fiasco. Now, I see a couple of worried faces in the audience, and no doubt they belong to those lawyers who have drafted contracts for U.S. deals and haven't bothered to put the arbitration clause in there. Well, don't despair. There's a tip for you too, and that's in Lesson 4. Lesson 4 is go federal. As soon as your Canadian client is sued in the U.S., get the case removed from the local state court system into the federal U.S. court system. It's not hard to do. When American lawyers are retained to act for a foreign company in U.S. litigation, this is usually the first thing they will do. They believe that the federal judges are more likely to determine the case on its merits than from political expediency. Remember that in the states, federal judges are appointed for life. They don't need to make politically correct decisions. In contrast, local state judges are voted into office by the American electorate, and in order to be voted back into office, they have to have a record of making the right decisions. In cases where one party is a foreign entity, guess which way the local state judge is going to rule. Lesson number 5, I call it the Canadian Shield. In your contract, specify the law of a Canadian province as the governing law. Doing so will prevent the application of certain U.S. state laws, for instance, those permitting extremely high awards for punitive damages. In conclusion, many Canadian companies and lawyers who followed the Lowen story probably thank their lucky stars that they were not doing business in the United States. But that's not the right lesson to be learned. The right lesson is that just like anywhere else in the world, doing business in the United States merits extra caution and proactive measures. Thanks.
Thank you, Elo. Moving right along, our next speaker is Edward Belobaba from Gowling, Strathy and Henderson, who will talk about financing business ventures in new markets such as China and Russia.
Thank you. Good morning. In my experience in international commercial work, the toughest issue is by far financing. Canadian companies typically have the talent, they surely have the product, the technology, but they don't have the capital, and they don't have Canadian banking support in the new markets that are particularly risky, such as Latin America, the former Soviet Union, and China. So today, I'd like to leave you with 3 very basic, but in my experience, very important points. Number 1, take full advantage, for your client's sake, take full advantage of the federal and provincial trade support programs that are out there to help your client kick the tires in the new market, to send over his engineers, to figure out what the feasibility of the deal might look like, etc. Number 2, don't give up when the Canadian banks say no, as they surely will. You have to go offshore for financing sources, but indeed they are out there. They are difficult to access, but not impossible, and few Canadian companies take the time or trouble to do so, unlike the Americans, Germans, and Japanese. And number 3, if you're particularly foolhardy, don't be afraid of counter trade. More than 2/3 of the world's population lives in markets where the currency is not convertible into U.S. dollars, and that is increasing, not decreasing. So the world of barter, offset, buyback, counter trade is a world that we in Canada will have to come to grips with in the years ahead, more so, not less so. So very quickly. It sometimes surprises big companies and small companies that there is some money out there, not a hell of a lot in times of cutback, but there is some money out there for clients to get together 2 or 3 of their engineers, financial people, even their lawyer, and go off to Hungary or Chile or China to see what the feasibility of the project is all about. And PEMD, the OITC, have up to $35,000 for these first trip kinds of assessments, market exploration projects, if you will. And once you get there, you lock into some kind of an on-site investment opportunity. Then indeed you want to look at feasibility of the project. And there again, many aren't aware of the programs with CETA that covers the globe except the former Soviet Union, and with regard to the FSU, Renaissance Eastern Europe. These are administered typically by External Affairs, or now called DFATE, the Department of Foreign Affairs and International Trade. There are application forms, there are some criteria for the number of years you've been in business, etc., but typically it ain't that difficult to get this first chunk of financing for that first stage of market exploration. Once you're beyond that, it gets incredibly difficult, but here again, we ought not to despair when the banks say no, because with some effort and some information, one can put together financings involving the IFIs. And the most important ones are clearly the IFC, the private sector trading or financing arm of the World Bank, and then the newly established 10 billion ECU-rich EBRD based in London. Now, these are large deal projects. They're sort of in the 15, 20, 25 million range, but they're good for up to 1/3 of the debt or equity in the deal. The promoter puts up 1/3, and then with the IFI, with the legitimacy of these major players of the World Bank Group, one can then co-syndicate or structure finance for the other third or the balance with European banks that aren't afraid of investing in these new markets. So here I leave you simply with some of the bullet points regarding the IFC and EBRD. These are 2 that we have done deals with from Canada. Less so the Asian Development Bank. I don't know much about that one, but I know that they are also on the map for private sector work. And the IDB very recently opened up its doors to private sector financing as well, and some of these points are set out for you. Also be aware, apart from the IFIs, and we all are as we think about our RSPs and whatever, of the huge slush fund or pool of capital in the North American, European markets that have to make their way eventually via Templeton and Framlington to the new markets. And we have, in fact, been fortunate with Canadian companies to access, for smaller projects, $2, $3, $4 million numbers to expand a project in China or in Russia. Been able to access some of these so-called country-focused funds. They exist for Latin America. They exist now for the Far East. And this is a list, just for your information, of the ones that are focused on the former Soviet Union. Framlington, based in London, is one that is very active and flies into Toronto regularly, or Ottawa or Calgary, talk to Canadian companies that want to look in the $1, $2, $3, $4 million range. And finally, when the Canadian bank says no, as they surely will, remember, and these are in your materials, that there are historically more confident banking groups in Europe that have been closer to the revolutionary days of the USSR or whatever, and Germany and England are not afraid to, in fact, deal with Canadians and help them access new market opportunities. And I provide in the materials, just again by way of illustration, a list of banks providing financing even into the world's most risky market. The riskiest market on the planet by far now is Russia. But even there, Chase Manhattan, Citibank, Morgan Grenfell, Credit Anstalt, Deutsche Bank, etc., are ready, if your business plan makes sense, to talk about what debt or equity play they can make to help you out in that particular market. Canadian banks, I think, having been burned in Latin America, are now probably too busy buying Bob Dylan records to worry too much about about the offshore, but our clients are forced into it because the Canadian North American market is dwindling, not expanding, and they will, and to their credit, many Canadian banks are trying to open up their eyes to the renewal of financing in these areas. And finally, and very quickly, the point I made earlier about more than 2/3 of the world's population being in non-convertible markets, we have to become more aware, and it's just something that we haven't gotten used to, given that the U.S. takes 85% of our exports, more aware of what Japanese have been doing since 1946, and that is developing trading houses to deal with the reality of non-convertible currencies. And what I do in the materials, and am I okay? It just set out very briefly some of the illustrations, if you will, that suggest how countertrade has been used historically for payment, the famous case being Pepsi sending syrup in exchange for Stolichnaya vodka, and now ships from Russia. And now, in fact, they're getting Russian rubles that are internally convertible, and the revenues coming back to Pepsi in Purchase, New York, are in U.S. dollars. But 3-4 years ago, they had to worry about what they do with the non-convertible currency. Beyond payment, though, the trickier aspect is financing, and a simple illustration, again in the material, shows you how Tambrand's U.S. company was able to finance their transfer, their sale in of machinery into this joint venture by persuading the new market partner to use countertrade and vend around the surplus cotton that would be used in the particular plant facility, use the sale of that cotton through escrow arrangements to dollarize the amount back to Tambrand's to have an advance payment before that machinery was sent out to, in this case, to Kiev, Ukraine. Last point, very quickly, is that this area of countertrade is an area that is only beginning to attract the interest of Canadian lawyers. It can get very complicated. This is a deal that failed miserably, but we tried our damnedest to pull it off in St. Petersburg, Russia. It almost came together. It was a bit too esoteric for the time, that maybe in 2 or 3 more years we'll be able to return and do something with it. So it is complex, but it is interesting, and it deals with the real world of non-convertible currencies. Thank you.
Thanks, Ed. Ed and I teach a Masters of Law class every Wednesday night, and it's with great trepidation that I cut you off, Ed.
Pleasure.
Our next speaker is John Janssen from Goodman Phillips Weinberg, who will talk about coping with NAFTA rules of origin.
Thank you. The reason we want to talk about the NAFTA rules of origin, the reason they're significant is that they are the key to taking advantage of the tariff preferences under NAFTA. Now, let's start off briefly. Why do we have rules of origin? What are they for? Now, the Canada-U.S. Free Trade Agreement and NAFTA each created and create a free trade area and not a customs union. Now, the significance of a free trade area is that each individual country, member country, retains its own tariff policy, whereas in a customs union, the member countries all have a common tariff policy and other border measure policy with respect to goods from non-member countries. So let's consider, we have NAFTA. The member countries are Canada, the United States, and Mexico. And we have a good imported into Canada from Mexico, and that good is a tomato. It's been grown in Mexico. Does Canada allow tariff preference treatment to that good under NAFTA? Well, of course, yes, that's perfectly reasonable. It's wholly Mexican. It wholly comes from within the free trade area. Now, let's suppose that you have a cassette player that's imported into Mexico from Taiwan and then is imported from Mexico into Canada. Are you going to allow NAFTA tariff preferences to that good? Well, no. It's a Taiwanese good, and just because it was transshipped through Mexico doesn't mean that it should get tariff preferences under NAFTA. Now, if we had a customs union, it would be quite another matter, because you'd have a commonly agreed policy when that cassette player entered Mexico, and that cassette player then could circulate throughout the customs union without any further rules to observe. But we have a free trade area, and the countries have their own different policies. So now the good, let's supposing we have a part for a cassette player that's imported into Mexico, and it's combined with other parts and things in Mexico to make a cassette player that is then imported into Canada. Do you allow tariff preference to that good? It's partly Taiwanese, but it's also partly Mexican. That's what you need the rules of origin for, is to answer that question. Now, in the world of rules of origin, basically what we have are goods and materials. And goods are the things that you produce, and materials are the things that you use to produce goods. And one person's good can be another person's material. A steel producer produces a slab of steel, that's a good. But when a brake shoe manufacturer buys that slab of steel and makes a brake shoe out of it, the steel is a material and the brake shoe is a good, and so on. Now, in rules of origin, we have a concept of originating and non-originating. Now, remember our cassette player made from the Taiwanese part in Mexico. It certainly doesn't matter to Canadian customs whether the parts, other parts, were Mexican or American or Canadian. It's all the same. So the rules of origin merely tell you whether a good is originating. It doesn't identify a good as being Mexican or Canadian or U.S. And then the other concept, of course, if the good does not meet the rules of origin, it is non-originating. And the same will apply to materials. If a material is imported from Taiwan, it's obviously non-originating. But also if you have a material that's made within an NAFTA country that does not meet the rules of origin, it also is non-originating. Now, there are two types of goods, basically. I hope you can see these, by the way. There are goods that are wholly originating, my tomato, and then there are goods that incorporate materials from third countries or non-NAFTA countries, my Mexican cassette player. Now, in dealing with our Mexican cassette player, or a good that incorporates, any good that incorporates materials that are imported from third countries, there's two basic ways that rules of origin, there's two basic approaches you can take. You can say the material has to have undergone a substantial transformation. In other words, the exercise of turning that material into the good has to have resulted in the creation of something that's different. And then the other approach is a value-added requirement. You have the Taiwanese part, and then you keep adding value to it until you reach a certain point. You've added enough value to it, and then the good becomes originating. The NAFTA rules of origin make use of both approaches. Now, under the rules, you have, basically, there's four ways. I'm only going to deal with three of them. There are four basic ways you can establish that a good is originating. Firstly, wholly originating, that's the tomato. Secondly, you can have a good that is made from originating materials. In other words, every material going into that good meets its own rule of origin. And you could have some imported items, submaterials in those materials, but your good is nonetheless originating because all the materials that you've bought to make it are originating. If you can't get under those, the third way is you have to look at what are called the specific rules of origin, and they are set out in our regulations, and also they're in Annex 401 to NAFTA. And they are set up in, they prescribe the transformation that has to take place by way of a change in tariff classification. Sometimes they provide for a value content requirement combined with a change in tariff classification. Occasionally there's a value content alone. In some instances, a specific rule of origin gives you a choice. You can have a tariff change alone, or you can have a tariff change combined with a value content requirement. Now, I think I've run out of time, and all the rest of this is explained in the materials.
John, thank you very much. Our next speaker is Richard Devenney from Kaiser Mason Ball, dealing with foreign exchange controls.
Good morning. What I'm going to be talking about really is Seminar 101 to Ed Belobaba's presentation. What I have tried to do in presenting you with a checklist of questions is really two things. One, to provide you with a practice tool that will help you understand the scope and breadth of a foreign exchange control regime, and secondly, to help you know what to do about them. And really, in a jurisdiction where you're going to be confronting one of these type of regimes, it's really of universal use. It doesn't matter whether you have a small, medium, or large-size transaction. The first part of it would be a set of questions you may wish to review with the local counsel that you retain. You want to make sure that it's an up-to-date understanding of what the foreign exchange control regime does. And the second part will be used for your planning purposes. Again, another one of those situations in life where failing to plan is planning to fail. Now, for those of you who wish to really get into this subject, there is a very helpful article by David Reed of Allen and Overy in the Negotiating and Structuring International Commercial Transactions materials published by the American Bar Association. And if you are still interested, you can go to David's partner's book, Philip Wood, The Law and Practice of International Finance, which was published in 1990, and there's more than you will ever want to know about foreign exchange controls in there. Foreign exchange controls are a historical tool of governments to maintain sovereignty and control over their economies. We find them more frequently in the developing countries, wherever they may be in the world, because of the fragility of the economic system involved. But even a market such as the United Kingdom had exchange controls up till 1979. So it's a very important question to deal with early on in your international transaction. You have to watch out for some special circumstances which come along from time to time, especially in enforcement. The applicability of the IMF agreement, Bretton Woods, as amended, started in 1944, and it has clauses that deal with what are known as exchange contracts, and it may mean that the ordinary rules of enforcement vis-a-vis and your choice of law in your agreement need to be carefully considered when drafting your contract. A factor which is important in dealing with foreign exchange control regimes are the negotiations of consents and permissions with the correct authority in the state that you're working in. You want to make sure that the ambit and the scope of the consent and permission is adequate for your purposes, and that following that the consent and permission and the transaction is registered in the appropriate authority in case there is a political change in the jurisdiction in question. I am going to be under 6 minutes, I hope, and I don't wish to say too much more. I think if you go through the checklist, you'll be able to deal with a foreign exchange control in whatever transaction that you're considering.
Thank you, Richard.
You're welcome.
Under time. Our next and second to last speaker is Bob Cosman from Fasken Campbell Godfrey, who will talk on international commercial arbitration, the Canadian perspective.
Good morning. In this trendy world of ADR, arbitration has long been a fixture in the resolution of international business disputes. It was favored by most of the trading world, certainly by Europe, Mideast, Asia, to a lesser extent the U.S., but only recently by Canadian business. And that is, I'm going to touch today, in the time that I have allotted, on why that is so, outlining the changes that support the use of that particular resolution mechanism today, which was not favored very long ago. Well, the first major reason that Canada was not a very hospitable place for international arbitration, or domestic arbitration for that matter, was that Canadian arbitration statutes until the mid-'80s were based on late 19th century arbitration acts of the UK, which did not adequately provide the underlying support for the arbitration process that was necessary. And I'll touch in a minute on some of the reasons that is so, but I want to say that today there is legislation across Canada which updates our arbitration legislation, and in particularly in the international area, there's legislation which implements the 1985 UNCITRAL model law on international arbitration. There are two primary thrusts of that legislation. One is that it provides for a mandatory stay if a party to a dispute attempts to go to court with respect to a dispute that is the subject of contract. It's mandatory, whereas under previous legislation, a court had a discretion. And I'll come to how courts exercise that discretion depending upon the interest of the court in the dispute in question, and not really, I would suggest, on a very principled basis. Secondly, under the UNCITRAL model law, there is a very limited right of review of arbitral awards once they have been made. A second point that made Canada an inhospitable place for arbitration was that Canada was not a party to the 1958 New York Convention on the Reciprocal Enforcement of Arbitral Awards. The rest, or most of the rest of the trading world was, and for a long time we shared the honors with Swaziland as not having joined that World Trading Club. Canada has since become a signatory to that convention, and today I can tell you from practical experience that the enforcement of an arbitral award is easier than the enforcement of a judgment from a foreign court, as between two signatory states. Thirdly, Canadian judges, as I indicated earlier, were really very jealous of their jurisdiction, believing that the justice that they dispensed was of a higher quality than that which was dispensed by arbitrators. And for that reason, awards were easily and often set aside in the courts. So parties that went to arbitration ended up having to go to court as well. I'll give you just two examples of that. Prior to the changes in the legislation, I had a number of cases in the Ontario courts where I was able to persuade a judge to set aside arbitral awards on the provision of the statute which permitted the court to set aside an award where a judge had, quote, misconducted himself, end quote. That had been interpreted in some of the jurisprudence in Ontario broadly to mean making an error of fact or law on the face of the record. So in the face of that wide review principle, as I said, a judge who was interested in your case, if you were before a court, you could often persuade him to set aside an award. So a party who had gone to arbitration because of the fact that it was an expeditious way to resolve a dispute found themselves going through two processes. A second example is 10 years ago, I was in the Supreme Court of Canada on an appeal from the British Columbia Court of Appeal. It was a case where there had been a dispute between a company in the UK and a company in Vancouver. There had been a lengthy arbitration, international arbitration in Vancouver. The unsuccessful party went before the BC Superior Court, persuaded a judge to set it aside. It had been reversed on appeal by the BC Court of Appeal, and about 10 years to the date that this speedy process was initiated, I was arguing in the Supreme Court of Canada, and the Supreme Court of Canada did uphold the BC Court of Appeal and the arbitral award. But the point was that the general counsel for the Vancouver company who had retained me had told me at that time that it was the last time that he was going to use arbitration as a method of dispute resolution, because not only had he paid for this lengthy arbitral process, he had gone through 3 levels of courts, and I'm here to say that with the change in the legislation and with change in judicial attitude, which is today very supportive of the process for a lot of reasons, which I don't have time to go into, such a scenario is highly improbable. Thank you.
Thank you, Bob. Our last speaker is Roger Cotton of Tori Tori, who will talk about international environmental management.
When I began doing environmental law in 1982, I was lucky if I was allowed to meet the plant manager. I was usually working with the occupational health and safety person and working on specific, what some might look at as small spills or other environmental incidents. Today I spend my days in the corporate boardrooms, board committees of environment and occupational health and safety, and I'm here to tell you that environmental management is the topic that they're dealing with. It's not to say that they don't care about the ozone layer or about greenhouse emissions or don't care about Greenpeace's next move. The fact is that major corporations now have full-time environmental managers, staffs of many people who are to deal with those kinds of long-term issues. What the board cares about, and their respective committees on this subject, is environmental management. I'm not going to bore you once again with the Bata case. You've probably all heard about Tom Bata and his president and his Canadian vice president being charged for some leaky barrels out behind the plant. But that case, and cases like it, and sentencing guidelines in the U.S. and so on, have driven companies to improve their environmental management and make it a board issue. If you're not familiar with the specifics of environmental management, these are the general topics that they would look at because of the liability that they perceive to the company as well as their own individual liability. They're concerned, first of all, that they have an environmental policy in place, and then they have specific environmental procedures on a whole host of subjects, and I've given you some examples here. In addition, we have ahead of us an ISO 14000 process. Many of you will be familiar with ISO 9000, which was quality. ISO 14000 is environmental management, and the guidelines for this ISO standard are now in place. Companies are moving forward and becoming ISO 14000 certified for their environmental management programs. That's a whole nother discussion as to what that does or doesn't do for a company, but it is going to happen, and you're going to see in Canada and across the world ISO 14000 become an environmental management standard. There are issues, obviously, that arise from it, and in preparing for this, I asked myself, what's the one issue that comes up the most for international companies? We now have many Canadian companies that have gone international. And it particularly arises where they've been used to the Canadian and U.S. environmental regime, and they then move, like a mining company, into Chile or some other jurisdiction where you have close to non-existent environmental regulation, or if you do have regulation, it's not meaningful regulation in the way that we have it. You also, of course, have jurisdictions like China where you have a whole lot of environmental law, but how it's enforced and dealt with are not according to the kinds of rules that we're used to in Canada. And so the one issue that comes up the most particularly for public companies, is what is our environmental standard? If a scrubber to reduce your air emissions at each of your plants costs, say, $50 million, do you install a $50 million air scrubber in your Chilean operation when there is no regulation that requires that? Or are you comfortable with having different standards for different jurisdictions? And if you are comfortable, how are you going to explain that to all the stakeholders and shareholders and others who might be keenly interested in how you operate across the world? You've heard the stories of Placer Dome in the Philippines. There's a long list of Canadian companies who already are under fire when an environmental incident occurs for the standards to which they're operating. I think this is going to remain the number one issue out there. It's not an easy one. It's probably easy in principle, but much harder to administer. I might just mention that in some local jurisdictions, they don't want you to operate to the higher North American environmental standards for a whole host of reasons, and that's a different political problem. My materials did not make it in time for your book. If you'd like to just drop off a card up here, I promise that I will get it into your hands as soon as possible, and my apologies for not delivering on time. Thank you very much.
Thank you, Roger. I did promise to finish on time. It's now 2 minutes to 12, which means I have 2 minutes for final comments. This is a tough program to put together because we try and hit an awful lot of topics. It's very much a generalist's program. Definitely we'd be interested in some feedback. It's our first time trying it, and obviously we're interested in trying to improve it. I would like you all to join me in thanking all our speakers for spending their time with us today, and thank you for coming.